Introduction. Rule of law is one of the cardinal principles of constitutional law and is deemed to be a foundational stone for the growth of administrative law. It is an eternal value of constitutionalism and an inherent attribute of democracy and good governance. It provides a criterion with reference to which one can evaluate legal structures, systems of governance of any society. The concept of rule of law. Doctrine of rule of one, rule of law is an animation of natural law and remains a historical ideal which makes a powerful appeal even today. It is the supreme manifestation of human civilization and culture and is a new lingua franca of global legal as well as moral thought. In fact, it is deemed to be a living concept permeating several branches of law and having great practical importance in the life of every human being. This doctrine has been a powerful instrument to control the administrative authority. Judiciary, through its interpretation, has quashed many administrative decisions on the ground of non-compliance with the different aspects, facets of rule of law. Origin of the doctrine. The concept of rule of law is not of recent origin but was in application from time immemorial. In ancient India, this concept can be traced to the Upanishads in the notion of dharma, duty. Early Greeks located the concept of rule of law in right reason which must inform all actions of the state. Aristotle advocated the rule of law by saying that it is advantageous to place the supreme power in some particular persons, they should be appointed to be only guardians and the servants of the law. In Islamic jurisprudence, rule of law was formulated in the 7th century, so that no official could claim to be above the law, not even the caliph. However, this was not a reference to secular law, but to Islamic religious law in the form of Sharia law. The Chief Justice Sir Edward Coke is said to be the modern-day originator of the concept of rule of law, when he asserted that the king must be under the God and the law, and in this way he established, vindicated the supremacy of law over pretensions of the executive. Later on this concept was developed and established by Dicey in his classic book, The Law and the Constitution, published in the year 1885. Meaning, effect of the doctrine. The basic concept of the rule of law is not a well-defined legal concept. In fact, it is a dynamic concept and capable of any exact, concrete definition. The term, rule of law, is commonly used in the sense of antithesis of the term, rule of prudence, or the rule of powerful men. This term is derived from the French phrase, le principe de l'égalité, the principle of legality, which refers to a government based on the principles of law and not of men. So the expression, rule of law, explains a state of affairs in which everything must be done according to law fixed and announced beforehand. Rule of law, in this sense, is a concept opposed to arbitrary or tyrannical powers on the part of the government and equality of all persons before the eyes of law. It implies that the law is supreme and foundation of a civilized society and every act must be done in accordance with law. Even in the most autocratic forms of government, there is some law according to which the powers of the government are exercised, but it does not mean that there is the rule of law. Therefore, rule of law means that the law rules, using the word law in the sense of jus as well as lex. Thus, the term rule of law can be used in two senses. In a narrow formalistic sense, it simply refers to organized or structured power as opposed to a rule by one man. In a broad ideological sense, it represents an ethical code for the exercise of public power in any country. Strategies of this code may differ from society to society depending on the societal needs at any given time, but its basic postulates are universal, covering all space and time. These postulates include equality, freedom, and accountability. Thus, rule of law is a system of government in which a society adopts or maintains a set of good, just, and fair laws by which it will be governed by the government. Opposite to this system is one in which the government can do whatever it wants and the people have no way to refuse laws which they consider unjust or unfair. Object, rationale, basis of the rule of law. Social life requires cooperation and order requires laws. It is possible to have order of some sort, by submitting to the rule of a leader, a dictator who is able to coerce the obedience. But such submission to the rule of men could involve loss of freedom and subject the people to whims of men. The ideal solution thus lies in the rule of law, which guarantees both order as well as freedom. Law may be taken to mean a rule or principle which governs the external actions of human beings and which is recognized and applied by the state in the administration of justice. Rule of law is one of the pillars of the modern democratic welfare state, and widely considered necessary for implementation and preservation of democracy, protection of human rights, and sustained economic development. According to Plato, if law is the master of the government and the government is its slave, then the situation is full of promise and men enjoy all the blessings that the God showers on a state. This doctrine was originated with the object to exclude arbitrary authority of the government, the king, and to protect the individuals from unlawful action of the government, the king. Now it is generally accepted that adherence to the rule of law is fundamental to and is one of the defining features of a civilized society. And the rationale of it is to provide a safeguard against arbitrary governance, whether by totalitarian leaders, elected governments, or mob rule. Dicey, an eminent British jurist and constitutional law theorist, highlighted the importance of rule of law in the following words: it means, in the first place, the absolute supremacy or predominance of 5. Regular law is opposed to the influence of arbitrary power, and excludes the existence of arbitrariness, of prerogative, or ever of wide discretionary authority on the part of the government. Englishmen are ruled by the law, and the law alone. A man may be punished for a breach of law, but he can be punished for nothing else. It means, again, equality before the law, or the equal subjection of all classes to the ordinary law courts. The rule of law, in this sense, excludes the idea of any exemption of officials or others from the duty of obedience to the law which governs other citizens or from the jurisdiction of the ordinary tribunals. Dicey's formulation of the concept of rule of law. The rule of law is an ancient principle and has been subject to many interpretations over the centuries. It is a phrase universally used but never comprehensively defined. Dicey elaborated his conception of the rule of law in his book, The Law and the Constitution, 1885, in the form of 3 principles. 1. Supremacy of law, absence of discretionary powers. Rule of law means absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power and excludes the existence of arbitrariness, of prerogative, or even of the wide discretionary authority on the part of the government. Dicey asserted that where there is discretion, there is a room for arbitrariness which may lead to threat to legal freedoms of the citizens. Rule of law also means that no man is punishable or can lawfully be made to suffer in body or goods except for a distinct breach of the law established in the ordinary legal manner before the ordinary courts of the land. This is the most fundamental feature of rule of law because it distinguishes between rule-bound regulated government and arbitrary government, suggesting that where rule of law exists, government cannot simply act as it pleases. For example, it cannot punish citizens merely because it objects to their opinion or disapproves of their behavior. 2. Equality before law. No man is above the law. Absence of privilege. Rule of law implies that there must be equality before law or equal protection of all classes to the ordinary law of the land administered by the ordinary courts. This is based on the well-known maxim, however high you may be, law is above you. All are equal before law. Law should not discriminate against people on the basis of race, gender, creed, social background, and so forth. It should be applied equally to ordinary citizens as well as to government officials. Every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. There is complete absence of any special privileges for a government official or any other person. He criticized the French legal system of droit administratif in which there were separate administrative tribunals. for deciding cases between the officials of the state and the citizens. According to him, exemption of civil servants from the jurisdiction of the ordinary courts of law and providing them with special tribunals was the negation of equality before the law, and it was incompatible with the rule of law. This led him to conclude that administrative law was utterly foreign to the British Constitution. 3. Predominance of legal spirit, judicial supremacy. In many countries, rights are guaranteed by a written constitution, but in England, rights of the citizens recognized by the constitution are the result of judicial decision in particular cases which have actually arisen between the parties. Common law of Britain is the source of fundamental freedoms of the people. And the constitution was not the source but consequence of the rights of the individuals secured in the judicial decisions in concrete cases. Dicey emphasized on the role of the courts of law as guarantors of liberty and claimed that rights would be secured more adequately if they were enforceable in the courts of law than by mere declaration of those rights in a document, as in the latter case, they can be ignored, curtailed or trampled upon. Dicey feared that if the source of the fundamental rights, freedoms of the people was any document, the right could be abrogated at any time by amending the constitution. In countries having a written constitution, a despotic government could amend the constitution at will and abrogate the rights of the citizens. In England, no such abuse of rights could take place because the rights of the citizens are not based on a written text but flows from the customs and traditions. In India during the 1975 emergency, the SC in ADM Jabalpur vs. Shivkant Shukla, Air 1976 SC 1207 ruled that even illegal acts of the government could not be challenged in a court because it was found that the source of personal liberty in India was Article 21 of the Constitution, which had been suspended by the presidential proclamation, and not any common law of the people. Dicey emphasized on the judicial supremacy as forming an element of the rule of law. Criticism of Dicey's concept of rule of law. Dicey's concept of the rule of law mainly applies to the British Constitution, yet his formulation is regarded as a beginning point of discussion on the subject of rule of law. His concept has been subjected to following criticism. 1. Discretion is indispensable. The first principle of Dicey's rule of law is the recognition of a cardinal principle of democratic governments as opposed to autocratic governments. The principle lays down that no functionary of the government should have wide arbitrary or discretionary powers to interfere with the liberty and freedom of the people. Dicey believed that, wherever there is discretion, there is room for arbitrariness. Dicey failed to distinguish between discretionary and arbitrary power. While arbitrary power is repugnant to the rule of law, discretionary power, unless exercised improperly, is not. The modern welfare state seeking to bring about development cannot function without discretionary powers. Even in 1885, when Dicey developed his thesis, there were many statutes in England, which conferred discretionary powers on the executive. According to Wade and Phillips, if it is contrary to the rule of law that discretionary authority should be given to government departments or public officers, then the rule of law is inapplicable to any modern constitution. Discretion must be exercised properly, and for this purpose, it must be subject to judicial review. What rule of law requires is that the courts should prevent the abuse of discretionary powers. When Dicey said that wide discretionary authority was inconsistent with the rule of law, he might have expressed his political philosophy, but he certainly did not express a principle of the English Constitution, for in fact wide discretionary power existed in England. In Indira Nehru Gandhi vs. Rajnarain, Air 1975 SC 2295, Justice Matthew observed, there has been no governmental or legal system in the world history which did not involve both rules and discretion. It is impossible to find a government of laws alone and not of men, in the sense of eliminating all discretionary powers. All governments are of laws and of men. If it is contrary to the rule of law that discretionary authority should be given to government departments or public servants, officers, then there is no rule of law in any modern state. Without discretion, it is not possible for the modern state to fulfill its obligations to the citizens. Consequently, providing the discretionary power to the administration is inevitable. The opinion of Dicey, thus, appears to be outdated as it restricts the government action and fails to take note of the changed conception of the government. 2. Fear of abuse of discretionary power is not tenable. Dicey's dislike of discretionary power was due to the fear of abuse. But all necessary discretionary powers has to be conferred by law notwithstanding the possibility of abuse, though it is usual to provide safeguards against abuse. But the safeguards may not always be effective. The administrative law is much engaged in finding out the new ways and means of the control to prevent abuse of the administrative discretion. The ultimate guarantee against abuse of power, legislative, judicial and executive, lies in the political and legal safeguards against such abuse, in a vigilant public opinion, and in a sense of justice in the people generally. Possibility of misuse or abuse of discretionary power cannot be a valid ground to prohibit completely conferment of discretionary powers. 3. Privileges and immunities. The second principle of Dicey's rule of law requires equal subjection of all persons to the ordinary law of the country and absence of special privileges for persons including the administrative authority. Dicey's insistence was that a government officer must be under the same liability for acts done without legal justification as a private individual. According to Dicey, the rule of law excludes the idea of any exemption to officials or others from the duty of obedience to the law which governs other citizens or from the jurisdiction of ordinary courts. But this proposition of Dicey has not been fully adhered even in England. Dicey ignored the privileges and immunities enjoyed by the Crown under the cover of the maxim that the king cannot do any wrong, and also ignored many statutes which conferred discretionary powers on the executive, and could not be called into question or tested in ordinary courts. Special protection has been provided to the officials by Public Authorities Protection Act, 1893. Foreign diplomats enjoy immunity before the courts. The Crown can terminate the service of its servants and it is not bound even by the express terms in the contract. The Act of State doctrine may provide a defense to actions in tort. Judges enjoy immunities from suit in respect of their acts done in discharge of their official functions. Thus, the meaning of rule of law explained by the Dicey does not represent complete picture prevailing at his time. 4. Misunderstood and miscomprehend the real nature of the French droit administratif. In his second principle, Dicey insisted that every person including government servants should be subject to the same body of law as well as to the same ordinary courts of the country. Dicey criticized the system of droit administratif prevailing in France. He observed that in France the government officials exercised wide discretionary powers and if there was any dispute between a government official and a private individual, it was tried not by ordinary courts but by special administrative court. The law applicable in that case was not the ordinary law but a special law developed by the special court. He was of the opinion that the administrative courts in France were established to protect the government officials. Consequently, he concluded that there was no rule of law in France. But the truth is that the French droit administratif, in many respects proved to be more effective than the common law system, in controlling the powers of the administrative authorities and in providing quick and effective remedies to the citizens against the excess or illegal action of the administration. Lord Denning said that far from granting privileges and immunities to public authorities, the French administrative courts exercise a supervision and control over public authorities which is more complete than which the courts exercise. In Forsyth observed, undoubtedly, the French Admiral Land, Wade and Attorney courts have succeeded in imposing a genuinely judicial control upon the executive and in raising the standard of administration. They are impartial and objective courts of law in the fullest sense. Though their judges are government employees, they are no less critical of administration than is the British judiciary. Later on, Dicey himself realized his misconception about the administrative courts in France. 5. Ignored the growth of administrative adjudication and of administrative tribunals. While formulating second principle, Dicey created a false opposition between ordinary law or courts and special law or tribunals. Dicey regarded it as a prime virtue of rule of law, that all cases came before the ordinary courts and the same general law applied to an action against a government official as well as against a private individual. He went on saying that rule of law is inconsistent with administrative tribunals. Dicey was against the separate system of administrative adjudication through tribunals. He claimed that there is no separate law or court for the trial of the government servants. But in fact, Dicey ignored the growth of administrative tribunals, quite a few of which had come into existence when he propounded the concept of rule of law, which adjudicate upon the rights of subjects not according to common law and procedure of Crown's courts but according to special laws applied to specific groups. Offences against military law or naval law are tried by court-martial. Ecclesiastical law is enforced by separate court. General Medical Council has been established to try the members of the medical profession for professional misconduct. In each and every modern welfare state, a large number of administrative tribunals have come into existence, which adjudicate upon the rights of the subjects not according to common, ordinary law and the procedure of ordinary courts but according to special laws applied to special groups. Thus, his antithesis was false in fact and untenable in principle. Later on, Dicey himself recognized that it may be necessary to create a body of persons for adjudicating upon the offenses or the errors of civil servants as such adjudication may be more effective in enforcing official law and moreover mere presence of a well-established law for all would not serve the purpose. Rather its righteous implementation by creating the special courts and the special laws. According to Garner, by no means, all disputes with the administration are subject to the jurisdiction of the ordinary courts. Many go to special independent tribunals instead, though, admittedly, there is generally an ultimate right of appeal on points of law to a court. Wade and Phillips rightly observed that rule of law is satisfied provided the tribunals are impartial and independent. That every man is heard before a decision is given affecting his rights. That reasons are given for decisions in reasonable regard. Is being paid to the President. Is being paid to the President. He has made it clear that the essential requirements are that decisions should be impartial and that those who give them should not be liable to pressure from the executive. 6. Ignored the presence and growth of administrative law. Dicey went on to say that administrative law was utterly foreign to the English constitution and concluded that there was no administrative law in England. Dicey appears to have reached this conclusion for he found a similarity between the French administrative law of his days and the institutions of the ancient autocratic monarchy. He had not thoroughly examined the actual working of the French droit administrative system. Dicey misconceived the administrative law because he thought that the French system is all about administrative law, while administrative law is much more than that. In fact, Dicey was concerned not with the whole body of law relating to administration, but with a single aspect of it, namely, administrative adjudication. His comparison was between the favorable position of an Englishman when in conflict with the state in contrast to that of a Frenchman in it. In fact, administrative law existed in England when Dicey's book was published in 1885. In his Law of the Constitution, he did not refer to the prerogative writs of mandamus, prohibition and certiorari by which superior courts exercised control over administrative action and adjudication. These writs belong to public law and have nothing to do with private law, and had he noticed those writs he could not have denied the existence of administrative law in England. But later Dicey realized the emergence of the administrative law in England. The famous decision of the House of Lords in Board of Education vs. Rice, 1911 AC 179, wherein the administrative agencies were authorized to decide even a question of law, made Dicey to state, the law of Britain was being officialized under the influence of socialistic ideas. He, however, attributed this change to the fact that government was undertaking to perform a large number of duties which earlier had not been regarded its concern, which led to conferring on officials the judicial and quasi-judicial powers. But he still asserted that so long as the courts dealt with a breach of law by an official, there could be no droit administrati in England and the rule of law would be preserved. 7. Constitution is recognized as the ultimate source of rights powers. The third principle of Dicey's rule of law in fact does not lay down any legal principle but merely explains peculiar character of the British constitution system, where common law is the source of fundamental freedoms of the people. The third proposition was based on distinguishing England from other countries having written constitution. The Constitution of Great Britain is unwritten and contains the principles evolved through judicial decisions. Here, the emphasis is on the role of judiciary in enforcing individual rights and personal freedoms irrespective of their inclusion in a written document. This meaning of rule of law does not hold good in the context of written constitutions of USA and India. The Constitution of India is not the result of the ordinary laws, customs and traditions of the land. In fact, ordinary law is also governed by the Constitution. Any law which is against the Constitution of India is declared void. Third proposition of Dicey has been criticized on the ground of unsubstantiated presumptions because the common understanding among modern nations has been that a written constitution with specified rights of the citizens provides better protection against abuses of the state. Conclusion. In spite of various shortcomings in the Dicey's concept of rule of law, the broad principles of rule of law have been accepted by almost all legal systems as a constitutional safeguard. It is consistently invoked in every modern democratic countries to keep control over the oppressive, capricious and arbitrary exercise of powers by the administrative authorities. Dicey fully succeeded in drawing the attention of the scholars and authorities towards the need of controlling the discretionary powers of the administration. It has served as a touchstone or standard to examine all administrative actions and to evaluate the administrative law prevailing in any country at a given time. The concept of rule of law has proved to be an effective instrument in confining the administrative authorities within their limits. Dicey's contribution to the development of administrative law must be acknowledged. He developed an universal philosophy of setting up a rule of law society, wherein no one is allowed to exercise uncontrolled or unlimited powers. He developed an universal philosophy to control the government and its officers and to keep them within their powers. The rule of law established by him requires that every action of the administration must be backed by law or must have been done in accordance with law. It is the universal philosophy which aims at elimination of arbitrariness and ensuring fairness and openness in the exercise of public power. Rule of law in India. Constitutional recognition to rule of law. A pre-constitution period. The concept of rule of law, in its ordinary sense of supremacy of law, had its roots in India from the very beginning of India's civilization. In ancient times, the rule of dharma prevailed in the form of dharma sastras or niti sastras. Even the king was under the rule of dharma and was not exempted from it. Upanishad states that law is the king of kings. Some of the important rules based on dharma sastra, niti Sastra and Artha Sastra were as follows. No decision shall be given. Sastra and Artha Sastra were as follows. No decision shall be given only by hearing one party, rather, they must hear both parties to a cause. B. They must not have any bias or interest in the cause. C. The hearing must be in the open in public view. D. They must not be prejudiced against either party for any extraneous reasons. A. They must pronounce judgment and give their reasons for their findings. Even during Mughal rule in India, the supremacy of law was recognized. However, when the East India Company invaded India, the concept of the rule of law as developed in England by Dicey was not extended to India. With the establishment of Supreme Court at Calcutta in 1774, an effort was made to make judiciary independent of the executive. However, the powers of the courts were weakened by the enactment of Settlement Act of 1781. B. Post-Constitution period. Rule of law in its modern concept was fully recognized and incorporated in India after independence, when in 1950 the Constitution of India was made the supreme law of the land. The Constitution embodies the concept of rule of law to its fullest extent. The international standards fixed for individual by the Universal Declaration of Human Rights, 1948, and ensuing conventions are present in our Constitution. The SC in Bachan Singh vs. State of Punjab, Air 1982 SC 1336 observed that the rule of law permeates the entire fabric of the Indian Constitution and indeed forms one of its basic features. The SC in State of Haryana Kha. Bhajan Lal, Air 1992 SC 604 observed, in our democratic polity under the Constitution based on the concept of rule of law, which we have adopted and given to ourselves and which serves as an aorta in anatomy of our democratic system, the law is supreme. The Constitution of India makes provisions not only for the establishment of the majesty of law but also for its protection or preservation. Following provisions of the Constitution makes it clear. 1. Preamble. The preamble of the Constitution sets out the different aspects of rule of law when it lays down the ideals and objectives of the Constitution in its opening words, i.e., social, economic and political justice, equality of status and opportunity, and fraternity and dignity of individuals in India. 2. Supremacy of the Constitution. Article 13. The Constitution has been made the supreme law of the country, and other laws, rules, regulations, ordinances, bylaws, notifications, customs and usages are required to be in conformity with the Constitution. Any law which is found to be in violation of any provision of the Constitution is declared invalid. Three. Fundamental rights. The ideals, objectives of the Constitution are further given concrete shape in Part 3 of the Constitution as fundamental rights of the individual and are made enforceable by the courts. These rights have been guaranteed against the state and its instrumentalities. Articles 14, 19 and 21 represent the foundational values which form the basis of the rule of law. 4. Equality. Article 14. The equality aspect of the rule of law is provided in Article 14, which provides for equality before the law or of the equal protection of the laws. Equality before law implies the absence of any special privilege in favor of any individual. It ensures that all are equal before the law. Equal protection of laws implies equal protection of all alike in the same situation and under like circumstances. The aim of both these concepts is equal justice. Article 14 strikes at arbitrariness in state action because an arbitrary action will involve negation of equality. 5. Freedoms. Article 19. Article 19, 1, enumerates or guarantees 6 fundamental freedoms to the citizens of India. The right to these freedoms is not absolute, but subject to reasonable restrictions which may be imposed by the state on any of the grounds mentioned in clauses 2 to 6 of Article 19. These freedoms are those great and basic rights which are recognized as the natural rights inherent in the status of a citizen. 6. Protection to unaccused. Article 20. The Constitution has taken care to safeguard the rights of persons accused of crimes. Article 21 prohibits legislature to make criminal laws having retrospective effect. Article 22 incorporates the principle of double jeopardy by providing that no person shall be prosecuted and punished for the same offense more than once. Article 23 protects an accused against incriminating himself under compulsion by providing that no person accused of any offense shall be compelled to be a witness against himself. 7. Right to life and personal liberty. Article 21 guarantees to all persons the right to life and personal liberty. It provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. The expression, right to life, has been given very wide construction to mean right to live with human dignity free from exploitation. The right to personal liberty has also been given wide construction. 8. Enforcement of fundamental rights. Articles 32 and 226. The Constitution does not only establish the rule of law, but also provides for its protection and enforcement. The judiciary has been empowered to act as the guardian and protector of the Constitution. Article 32 makes it clear that in the case of infringement of the fundamental right, the right to move the Supreme Court is itself a fundamental right. Article 226 enables the High Courts to issue writs for the enforcement of fundamental rights and also other ordinary legal rights. These two provisions provide the right to constitutional remedies. 9. Judicial supremacy. Articles 141, 142 and 144. Article 141 stipulates that the law declared by the Supreme Court shall be binding on all courts except the Supreme Court within the territory of India. Article 142 provides that the Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as necessary for doing complete justice in any cause or matter pending before it. Article 144 makes it clear that all authorities, civil or judicial, in the territory of India shall act in aid of the Supreme Court. 10. Independence of judiciary. Independence and impartiality of the judiciary is the first condition to ensure liberty and rule of law in a democratic setup of government. The Constitution makes sufficient provisions, Articles 50, 124, 217, 218, 222, 125, 221, 146, 229, 129, 215, 138 to ensure independence of judiciary. 11. Judicial review. Judicial review of the executive and legislative actions has been guaranteed through several constitutional provisions. Apart from these provisions, the Constitution of India contains several other provisions from which it can be safely concluded that the Indian Constitution embodies the modern concept, version of rule of law to its fullest extent. Parliament and state legislatures are democratically elected on the basis of adult suffrage. Article 265 provides that no tax shall be levied or collected except by authority of law. Besides, Article 300A provides that no person shall be deprived of his property save by authority of law. A person cannot be deprived of his property merely by the executive order or executive direction. Thus, by virtue of the Constitution of India, the rule of law pervades over the entire field of administration and every organ of the state is regulated by the rule of law. The entire scheme of the Constitution of India reflects this truth. Judicial trend on the rule of law, different aspects of the rule of law. The Supreme Court of India, as the guardian and protector of the Constitution, has recognized the rule of law as part of the basic structure of the Constitution and has held that the rule of law constitutes the core of our Constitution and it is the essence of the rule of law that exercise of power by the state, whether it is the legislature or the executive or any other authority, should be within constitutional limitations. The SC in AK. Kripak vs. UOI. Air 1970 SC 150 observed that rule of law runs. Authority. It must be exercised. Authority. It must be exercised in a reasonable manner and should not be exercised arbitrarily. The SC observed, the absence of arbitrary power is the first postulate of the rule of law upon which our whole constitutional edifice is based. If the discretion is exercised without any principle or without any rule, it is a situation amounting to the antithesis of rule of law. The SC in Air India v. Nargesh Mirza, Air 1981 SC 1829 held that the termination of service on pregnancy was manifestly unreasonable and arbitrary and was, therefore, clearly violative of Article 14. 3. Meaning of law. In the context of rule of law is above law. Justice Bhagwati explains the meaning of law in the context of rule of law in Bachan Singh vs. State of Punjab, Air 1982 SC 1325 in the following words. The rule of law permeates the entire fabric of the Constitution and indeed forms one of its basic features. The rule of law excludes arbitrariness, its postulate is intelligence with passion, and reason free from desire. Wherever we find arbitrariness or unreasonableness, there is denial of the rule of law. Law in the context of rule of law does not mean any law enacted by the legislative authority, however arbitrary, despotic it may be. Otherwise, even in dictatorship, it would be possible to say that there is rule of law because every law made by the dictator, however arbitrary and unreasonable, has to be obeyed. In such a case, even where the political setup is dictatorial, it is the law that governs the relationship between men and between men and state. The law itself in such a case being an emanation from the absolute will of the dictator, it is in effect and substance the rule of man and not of law which prevails in such a situation. What is necessary element of the rule of law is that the law must not be arbitrary or irrational and must satisfy the test of reason, and the democratic form of polity must seek to ensure this element by making the framers of the law accountable to the people. A state of negation of rule of law would not cease to be such a state because of the fact that such a state of negation of rule of law has been brought about by statute. 4. Rule of law and human rights. By an activist interpretation, right to equality, Article 14, right to freedom, Article 19, and right to life and personal liberty, Article 21, have been converted into a whole lot of human rights jurisprudence. The expression, right to life, has been given very wide construction. The SC in Bandhwa Mukti Morcha 2. UOI, Air 1984 SC 1099 observed that, right to life should be taken to mean right to live with human dignity free from exploitation. The state is bound to assure the observance of the labor legislation enacted for securing human life or human dignity, and an action on the part of the state in implementation of such legislation would amount to denial of the right to life with human dignity enshrined in Article 21. Similarly, the SC in Olga Tallis vs. Bombay Municipal Corporation, Air 1986 SC 180 made it clear that the expression, right to life, includes the right of livelihood also. Further, the term, personal liberty, was interpreted widely. The SC in Menka Gandhi vs. UOI, Air 1978 SC 597 held that the expression, personal liberty, enshrined in Article 21 is of widest amplitude, and it covers a variety of rights which go to constitute personal liberty of man, and some of them have raised to the status of distinct fundamental rights and given additional protection under Section 19. In Sunil Batra vs. Delhi Administration, Air 1978 SC 1975, the SC held that the right to life and personal liberty cannot be taken or curtailed except according to the reasonable, fair and just procedure established by law. The SC in Veena Sethi vs. State of Bihar, 19822, S.C. C. 583 recognized another facet of the principle of rule of law by observing that, what meaning has the rule of law if the poor are allowed to languish in jails without the slightest justification, as if they are castaways of the society? The rule of law does not exist merely for those who have means to fight for their rights, and very often for perpetuation of the status quo which protects and preserves their dominance and permits them to exploit large sections of the community. It exists also for the poor, downtrodden, the ignorant and illiterate who constitute the large bulk of humanity in this country. It is the solemn duty of this court to protect and uphold the basic human rights of the weaker sections of the society, and it is this duty we are trying to discharge in entertaining this PIL. 5. Rule of law in criminal justice system. The SC declared free legal aid to the poor and speedy trial in criminal cases as necessary adjuncts to rule of law. The right to fair trial is held to include fair investigation, stating that every investigation must be judicious, fair, transparent and expeditious, to ensure compliance with the rule of law, as is required under Articles 14, 19 and 21, the SC in Karan Singh vs. State of Haryana, Air 2013 SC 2348 said that ethical conduct on the part of the investigating agency was absolutely essential and there must be no scope for any allegation of malafidus or bias. The investigating officer has to ensure that an innocent person should not suffer from unnecessary harassment of false implication. Stating that fair trial is the very heart of criminal justice and in a way, an important facet of democratic polity that is governed by rule of law, the SC held its denial is crucifixion of human right. The SC in Zahira Sheikh vs. State of Gujarat, Air 2004 SC 3114 observed, the principles of rule of law and due process are closely linked with human rights protection. Such rights can be protected effectively when a citizen has recourse to the courts of law. It has to be unmistakably understood that a trial which is primarily aimed at ascertaining truth has to be fair to all concerned. It will be not correct to say that it is only the accused who must be fairly dealt with. That would be turning Nelson's eyes to the needs of the society at large and the victims or their family members and relatives.